Hello everyone, this is Shiv Prem, legal intern at LEXIS and Company, and currently pursuing BLLB honors from Central University of South Bihar. So, in the today's session, I will analyze the contract of agency. This topic will also be covered in two parts. In the first part, I will go through the introduction section, the creation of agencies, types of agents, sub-agents, and the termination of agencies. And in the next video, I will be going through the agent's duties to principal, principal duties to agent, the rights of agent, and that's all. So let's start to the introduction part. So at the point when one gathering gives some power to another gathering, whereby the latter plays out his activities in a pretty much free manner. For the primary party, the condition between them is called an organization. Organization can be expressed or suggested. Section 10 of the Indian Contract Act 1872 arranges the law identifying which agency. It is critical to realize the law identifying with organization on the grounds that essentially all business exchanges overall are helped out through office. All partnerships, large or little, help their work out through organization. In this matter, in this manner, laws identifying with the organization are a significant territory. Connections identifying with the head and the specialist include three principal parties: the principal, the agent, and the third party. Let us see with an example. Like Lavanya lives in Mumbai, but she owns a shop in Delhi. She appoints a person named Susan to take care of the dealings of the shop. In this case, Lavanya has delegated her authority to Susan, and she becomes a principal while Susan becomes an agent. And when the third person will come to buy that shop, then that person will be called as third party. So now let us see the criteria for being an agent. According to section 184, the person who had attained the age of majority and has a sound mind can become an agent. A sound mind and a mature age is a necessity because an agent has to be answerable to the principal. Minors and persons of unsound mind cannot be appointed as an agent. Now let us see how an agency is created. An agency can be created by three ways: the direct appointment, necessity, and ratification. In the direct appointment, when a person in writing or a speech appoints another person as his agent, an agency is created between the two. And the second point was necessity. In a situation of necessity, one person can act on behalf of another to save the person from any loss or damage without clearly being appointed as an agent. This creates an agency out of necessity. Now the third point is ratification, and when an act of a person who acted as another person's agent on his behalf without his knowledge is later ratified by that person, this creates an agency by ratification between the two. Now, let us see the types of agents. There are various types of agent like special agent, general agent, sub-agent, co-agent, factor, broker, auctioneer, commissioner, deal credit, and others. You may go to the definitions by your own. It is very long. It will get longer when I start elaborating this. So now let us see what is the authority of an agent. Authority of an agent can be expressed or implied. According to section 187, authority is said to be expressed when it is given by words spoken or written. Now the implied authority is According to the section 187, authority is said to be implied when it is to be inferred from the facts and circumstances of the case. In carrying out the work of the principal, the agent can take any legal action. That is, the agent can do a lawful thing necessary to carry out the work of the principal. Now let us see sub-agent. An agent may sometimes delegate the duty that has been delegated to him by the principal to somebody else. Ordinarily, an agent cannot delegate the duty he is supposed to perform himself to another person. Delegatus non protest delegare. Except in particular circumstances where he must, out of necessity, do so. Section 191 of Indian Contract Act 1872 defines a sub-agent to become a person employed by acting under the control of the original agent in the business of the agency. So now let us see how an agency gets terminated. An agency can be terminated in 5 different ways. When the agent's authority is revoked by the principal, when the agent renounces the business of the agency, when the business of the agency is completed, when either of the parties dies or become mentally disabled, when the person is adjected and insolvent. That's all for this video. I will be covering the other parts, the duties and principles and rights and others in the next video. That's all for now. Thanks for watching. Have a nice day and please do like and subscribe the channel. Thank you.